Joshua, you're welcome. Good afternoon. Thank you for joining. Joshua, let's start by asking if you can walk us through the key points of the Federal High Court regarding Natasha Akpoti-Uduaghan's recall.
Well, good afternoon to you, Mazino, once again. The fact is, the court alluded to the fact that the suspension was on the ground rules of the Senate and the Legislative Act. The Senate Standing Order 8 and the Legislative Act, Section 14, subsection 2 of the Legislative Act actually gave the Senate the right to suspend any senator who's found wanting of breaking a particular rule, procedure, or protocol. And particularly the reason why she was suspended was as a result of her outburst in the last time she was in the House, where she rose up to speak, alluding to the fact that she was not on a particular seat that was appointed to her. And we must understand that the Senate President has the sole prerogative of appointing. At that particular point in time, that seat was not the allocated seat to Senator Natasha Akpoti-Uduaghan. But the judge made some remarks. She said, I do not think that the Constitution envisages this particular issue at hand. That is a 6-month suspension handed to Senator Akpoti-Uduaghan, and that this senator is expected to represent her people in a specific number of times per year, days per year particularly. And the Constitution states that the legislative year of each calendar year is 181 days, that is 36.2 weeks. And as regards that, she was suspended for 6 months, that is 180 days, that is almost 6 months. The judge then went further to say that the Senate should be specific, and should not be at large. That is, that the Senate rule can be specific in the number of years that they are to suspend a senator, that they can't suspend a senator for that lengthy time of almost a year of a legislative year, and that she believes that the Senate has the power to revisit that particular section of the Constitution and revise them, as well as their standing order, and readjust them for the time being. Then she went further to say that to make a law that has no ending is excessive. That is the words of Justice Imarayi, that this particular law was excessive because the law states that the Senate can at will suspend any senator infinito. So it did not give a particular point, a particular timeline that a senator should be suspended. So she believes that that particular law was excessive. And she went further to say that, I'm quoting Justice Imarayi, I am of the opinion that the Senate has the powers to review the Senate rules and amend Section 14 sub 2 of the Legislative Act and the Senate order. She went further to say, now passing judgment on the case of her suspension, the Senate can, and I believe, recall the senator to allow her represent the people who sent her there. Now, there has been controversies if this particular words of the judge was an order, but I can confirm to you that the judge did not order anything, because it was more or less an opinion. You heard the counsel representing the Senate presidency, so that it was more or less an opinion, because she was of the opinion that the law can be adjusted, amended to give a specific time that you can suspend a senator. She now went further to say that she believes that the Senate can and we should recall Senator Natasha Akpoti-Uduaghan to represent her people as soon as possible. And now of course, the Senate has started reacting to the that particular judgment, saying that that particular ruling does not mean that they will call her immediately. So we are expecting the Senate to react and maybe to act on what the judge has said at the last sitting.
Well, thank you for that clarification, because it would seem that most people think that she's being recalled immediately, but I think you've cleared that out. Let's talk about the issue about the fine, the 5 million naira fine that was imposed upon her. And also, how does the satirical letter that she wrote to the Senate play in here?
Well, you recall that Senator Akpoti-Uduaghan made a satirical post addressing the Senate President, that's the President of Gospel Akpabio, on Facebook. That particular post was brought to the notice of the court, and earlier on the court has issued a gag order saying that no social media post, no publication, press release or press addresses should be granted as regards this case. And the lawyer representing Senator Akpoti-Uduaghan came to the court and argued that this was not relating to, that is, the social media post was not relating to the case in court. However, the counsel representing the Senate President of the Senate argued that this was the main issue as regards how this issue came to be, that it was as a result of this sexual harassment allegation that breadth the entire timeline of the legal battle that they had, and it's a particular reason, one of the particular reasons, the root causes of why this issue of a suspension is in court, where the judge, however, ruled that no one is above the law, and that you cannot choose to obey a particular order of the court, that this is not a criminal procedure. If it was, she would have been sent to a correctional facility. So particularly, this is a civil procedure, and as regards that, she will be there will be remedy to that, and the remedy for her to be purged of all this contempt is that she will pay a 5 million fine to the registrar of the courts, and she would publish an apology letter to the courts, not to the Senate president, to the courts. In that particular medium, she used to disseminate that particular satirical letter, and she would publish 2 apology letters in 2 national dailies addressing the court, not the president of the Senate. So that was the wisdom of the court, and they believe that it was employed in due course and in good faith.
Joshua, thank you very much for giving us the details to what happened in court. We will, of course, be waiting for your report on this, or perhaps maybe invite you over on the news again. Thank you.